Welcome to today's episode of Untoward Law. In today's episode, we will be looking at Khul'I Divorce under Islamic law. Most importantly, the court has reiterated how a Muslim man should treat his wife. Follow the screen as the story unfolds.
Sometime in 2015, a Muslim woman approached the upper Sharia court, Condone, Katsina State, for the dissolution of her marriage. Prior to her going to court, she would always cry to her mother that she was fed up with the marriage.
My dear, I have taken note of everything you have complained about. However, insult from a partner is not enough to abandon your marriage. Please be a little patient. Everything will be fine. Mummy, you will not understand. I have exhausted all my patience. I am tired.
Where is this foolish woman? You foolish woman. Come and bring my food. This night will be hot for you if you waste my time.
Did you hear that? Even in your presence. And you want me to continue to tolerate him? I am done with this man. I deserve respect too. Am I not a human with dignity? Okay. We will continue this conversation tomorrow. I will inform your father.
See the tasteless food you even prepared. You are shameless.
I have no words for you tonight. I am tired of you.
As she lay in bed that night, she took a decision. She was done with the marriage. Few days later, her lawyer filed a petition for Khul'I Divorce under Islamic law. Khul'I in Islam is a dissolution of marriage granted by a husband on the basis of financial consideration offered by the wife. That is, the return of the bride price. The case was instituted at the Upper Sharia Court, Condone, on 17th day of June, 2015.
Call the first case.
Aminu Sanasi vs. Mabruka Aminu. 2020, 2 NWLR, Part 1709, 437. My lord, parties are in court.
Any legal representation?
I am Fatima Abbas. I am appearing for the petitioner.
I am Abdul Salam Kazim. My appearance is for the respondent.
Open your case, counsel. Call the petitioner.
Very well, my lord. Madam, please tell the court who you are. My name is Mabruka Aminu. What do you want the court to do for you? I put a case against Mr. Aminu. I want him to divorce me. I am tired of the marriage. Why do you want to divorce him? He is always insulting me. The insult is too much. I can no longer bear it. I have chosen to die rather than go back to his house. That will be all, my lord.
Counsel, call the respondent.
Very well, my lord. Please tell the court your name.
I am Mr. Sanasi Aminu.
Is the petitioner your wife?
Yes. She is my wife.
She has brought a petition for divorce. What do you have to say about that?
I have heard what she said. However, I love my wife. I love her very much. I do not want to divorce her.
That will be all, my lord.
Marriage is a beautiful union. However, as the petitioner has approached the court, we will do our best to make sure that the best decision is taken. I will adjourn this case. Parties are to bring their guardians to have a talk with the court.
The matter was adjourned. The couple brought their guardians as requested by the judge. The court took them in chambers to have a talk.
I understand what you may be feeling now, but I suggest we give it a try. If it does not work this time, we will go ahead and divorce you too.
Thank you, sir. I appreciate all your concerns. But I would rather die than go back to Aminu.
My dear, I love you. Listen to the judge. Okay, let me speak to your guardians. Okay, sir. Thank you. I will tell them to join you. You are welcome. Please sit down.
Thank you, sir.
What is the situation? I learned you called a peace meeting at home. How do you suggest we proceed?
From my observation, my ward has made up her mind. She insists she would rather die than go back to him.
Do you also share the same sentiments, Ma? Women understand these things better.
Yes, sir. My daughter-in-law does not want to remain married to him anymore. I agree that the court should set them free. Marriage is not what should be forced on anybody.
Okay. We will continue in court.
Since the reconciliation exercise failed, the court reconvened in the courtroom and delivered its judgment.
The marriage between Aminu Sanasi and Mabruka Aminu is hereby dissolved. Mabruka Aminu will pay 30,000 naira to Aminu Sanasi as Khul'I. She will do 3 monthly periods. Any dissatisfied party can appeal to Sharia Court of Appeal, Katsina, within 30 days.
Dissatisfied with the judgment of the trial court, Aminu Sanasi appealed to the Sharia Court of Appeal. On the 20th of October, 2015, the Sharia Court of Appeal dismissed the appeal and affirmed the decision of the trial court. Still dissatisfied, he made a further appeal to the Court of Appeal. The issue before the Court of Appeal was whether the Sharia Court of Appeal was right when it affirmed the decision of the trial court on Khul'I without regards to the money Aminu Sanasi spent on his wife during the marriage. In simple terms, Aminu argued that the ex-wife ought to pay him more money instead of the 30,000 naira ordered by the trial court. His lawyer argued in the following words.
My lord, Khul'I is not only restricted to the return of dowry by a woman who seeks divorce, but also include the payment of money to the man to help him remarry another woman. My lord, what the trial court ought to have done is to order the respondent to pay the appellant some reasonable amount of money to enable him remarry another woman, apart from the dowry. The respondent ought also pay for other expenses my client incurred during the subsistence of the marriage. I pray my lords to so hold.
Present your argument, counsel.
Very well, my lord. My lords, the argument of the appellant that he is entitled to recover from the respondent other marital expenses that he incurred in marrying the respondent is not well taken in law. This is because, under Sharia law, he was only entitled to be refunded the sum of 30,000 naira paid by him as dowry as rightly ordered by the trial court. I pray my lords to dismiss this appeal as it lacks merit.
After the argument of counsel, the court delivered its judgment.
I have duly perused the record of appeal. I have also given adequate consideration to the submissions of learned counsel for the parties. Basically, Khul'I is a dissolution of marriage granted by a husband on the basis of financial consideration offered. That is, the return of the bride price. In the instant case, it is glaring that, despite the standpoint maintained by the appellant before the trial court, that I love my wife, the respondent repeatedly stated that she has chosen to die, rather than to remain as the wife of the appellant. It is to be noted, and significantly too, that under Islamic law, it is permissible for a wife to be released in her own right, as a result of certain personal reasons, which she is not obliged to disclose. In Islamic law, the sums of money or items, which are regarded as refundable or claimable, are the ones which are proximate with essential requirements of marriage. Thus, incurred expenses and items which a husband gives to his wife, in the categories of gifts or general expenses, are not claimable or refundable in the case of Khul'I divorce. Indeed, the claimable or refundable items must fall within the ambit or classification of dowry or things that are incidentals thereto. According to the teachings of Islam, men are protectors of women. Hence, Islamic law does not condone any attitudinal disposition which is punitive, untoward, unwholesome and burdensome to women, talk less of a wife. This is more so, because when the man takes a woman as a wife, he is enjoined to treat her with affection and compassion. Thus, it is both legal and logical that in Islamic law, when peaceful coexistence has taken flight between parties as a married couple, the ideal antidote to be administered or applied, in order to protect the highly rated institution of marriage, is to dissolve the marriage. Couples should live in peace and not in pieces. I am of the firm viewpoint that given the peculiar facts and circumstances of the instant case, the lower court was right when it affirmed the previous decision of the trial upper Sharia court. Having resolved this issue in the manner stated above, it stands to reason that the appeal must therefore fail. It fails, and it is accordingly dismissed. The judgment and orders of the trial upper Sharia court, as affirmed by the lower court, are thereby affirmed by me. I make no order as to costs.
Welcome back. According to the teachings of Islam, men are the protectors of women. Do you protect the women in your life or abuse them? If your answer does not tally with the position of the court in this case, then you have a problem. Please subscribe to my channel. Bye. See you soon.